Check, 1, 2. Welcome to the January 25th, 2022 Zoning Board of Appeals meeting at the Town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to go ahead and do roll call. We'll start with you, Tom.
Tom Hennessy.
Greg.
Greg Dean.
Thank you. And David Murch. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you're unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number one, call to order. Number two, approval of minutes of November 30, 2021 meeting. Old business, of which we have none. New business, a public hearing for applicants Sarah and Matthew Holland. Number five, a board interview with Frank Miller. And number six, code enforcement officer communications. And then finally, adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, their address, and their affiliation with the application, being either for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chairman. Finally, this meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So, looking at our agenda, really first up is approval of minutes of the November 30, 2021 meeting. Because we're doing Zoom, we'll have to do a roll call vote on this. But do I have a motion to approve those minutes?
I'll move to approve them.
Do I have a second? So you muted yourself there, Tom.
Second, sorry.
So again, we'll have to do roll call vote. Tom, in favor of approval, yes or no?
Yes.
Greg, in favor of approval?
In favor, yes.
David is also in favor of approval of the minutes, so unanimous on that. Old business, of which we have none. So moving on, next is our new business, a public hearing for applicants Sarah and Matthew Holland for property location at Jordan Lane, map lot 3510, zone LRR1. Description of the application is for a setback variance, both front and south sidelines. A site walk on this property was held on Saturday, January 15th, 2022 at 9 a.m. Tom Hennessy of the ZBA was in attendance. David Murch, Greg Dean, and Patricia Beaton, all of the ZBA board, were unable to attend. So Tom, if you could just give us just a quick rundown, just a quick report with regards to the site walk.
Sure. First of all, you missed the -4-degree weather at 9 o'clock that morning. So, congratulations. Sarah Holland and her daughter were present. Sarah's uncle was there, and the abutter to the north side, Mr. Perry, was also present. The only question I asked was about the property markers that we asked a few months ago, whether they had found the markers close to the road. And the answer basically was no. And then the other discussion was Mr. Perry, the neighbor to the north, was concerned about any impact to his plans in the future to drill a well and install a septic system. And since then, I've seen the letter that he submitted to the town. The site walk lasted less than 10 minutes and we adjourned.
Okay. And I'm sorry, Tom, can you confirm for me, were both Matthew and Sarah there, one and or the other?
Just Sarah and her daughter.
Okay, thank you. So we will move forward with this. First off, by asking Matthew and or Sarah if you can give us an overview of what's being asked of the board tonight with regards to this application.
Okay, great. So this is about the property on Jordan Lane, and we're asking for a zoning variance so that we can build a full-time residence on that property. It's a setback reduction of 15 feet to the front and 10 feet to the north side. We've reviewed the 4 requirements for requesting a variance. I don't know if you want me to go through those 4 things or.
Sorry, I just wanted to make a quick note here to myself. We do have the information with us. I think that if it works for you, unless there's something that you feel was not accounted for in the application and you wanted to bring up now, we can probably review those as a board. And if necessary, ask you for clarification. However, if there are any items of this or for which you want to speak to, certainly you can move forward with that as well.
We have, since that walkthrough, we did contact the surveyor to try to identify those markers. That's in the works. So that's a pending item.
Okay.
We reached out to the original survey, Maine survey consultants. So.
Okay. I did notice in the application that I believe it says it says a survey was commissioned in 2016. Is a copy of that survey available?
Yes, and that was included. That should have been included in the packet that was submitted.
Okay, I just wanted to confirm that's what we had.
Yes, yeah, that's it.
Dated 12/20/2016.
Yep.
Okay.
And like I said, we did reach out to them. Everybody's busy these days, so it's just hard to get them there. But we will definitely get those pens reset.
Okay. Is there anything else you wanted to introduce at this point or to comment on, or?
I don't think so. I mean, we just, would love to be able to build a house there to live in. So that's
right.
why we're here today. So I know we already went through this once before. We didn't have the right, I guess, with the existing structure is what we're running up against. So.
Sure. And just to confirm it for the public, and Tom had mentioned as well, we had done a previous site walk on that, and that was with regards to a permit, with regards to a request for a setback reduction, during which we talked on, I think it was a couple of months ago, and it was determined that the property did not qualify with regards to that. Therefore, the application was withdrawn, and therefore we're reviewing it now as a setback variance. So, Tom, did you have any immediate questions for Matthew?
Just a quick question, or I'll say clarification. In the application, it says north side 10-foot reduction one place and south side another place in the application. And from what I understand, it's truly is the south side.
It is the south side. I apologize for that error.
Yeah, thank you for asking that, Tom. That was one of my questions as well. Craig, did you have any immediate questions for either Sarah or Matthew?
Another clarification actually is, it looks like it's signed by Daniel Wayland. Is that the co-owner of the property or?
Correct. That's my brother and a co-owner of the property.
Okay, yeah, I recall from when we had this conversation before.
We didn't have his signature last time.
Yeah. So, and then just to make it really clear, I mean, just so that there is some confusion and we're all remote, can you just once again, just summarize which sides? Is it the road and the north? So the east and north side of the reduction?
Yeah, I'm very sorry about that error there. It is, it's the road side and the south side.
The road and the south side, okay.
Yeah, so it's the side that's abutting Wyland, which is
my parents.
Sarah's parents.
And
And Andy Wyland is actually, Nancy and Andy are on this call. But so it's not the Perry side.
Okay.
And just so to confirm, if we're looking at the property from the road, you're asking for a setback reduction from the side, which would be on the left, correct?
Correct.
Yeah.
Okay. One question, actually two questions, but one question I had is, what is the reason for your request for the front setback or the roadside setback?
I mean, the front one is the more critical of the two. Without the front setback, the sort of the building envelope is only about 6.5 feet for the majority of the envelope. There is a little bit of a jog out where it gets slightly bigger as it approaches the Wineland property. But so that's the one that's really causing us the hardship of trying to figure out how to build a house with a footprint that's reusable. And then the setback to the south that we're asking for is just so that we can give us a little bit of space to the Perrys, pushing the building as close as possible to the Wineland camp, which is a camp that Sarah's parents will continue to own, and we would like to have a closer connection to that camp.
So what is the building envelope size or the building envelope size without the setback reductions?
It's only 6.5 feet wide.
Oh, you're asking for like a square footage?
No, the 6.5 feet wide is good. What about from the width, say the length of it?
The length
Envelope
is,
size without the setback.
I think it's 90 feet. So we're trying to fit, we need to fit the septic tank field and chambers within that space, and then the setback from those chambers to the house. So that's eating up, I don't know, 20 feet to the Perry side.
Okay, yeah, I probably should have phrased this a little better. I do appreciate the 90 feet and looking at that. What about the actual building itself? What would its width be?
So the building itself is
6.5 by what?
the building, the main structure is 57 feet with a 14-foot porch on one end and a 5-foot porch on the other.
He's asking if you didn't have the.
If I didn't have the 5 foot, the 10-foot setback,
That's fine. You're giving me the 57 plus 5 plus 14, so I can take that and subtract out 10.
Okay.
So
He's asking what you could build without the variance.
yes, I mean,
6.5 by what, 40 something?
yes,
well, I'm showing if you have 57 feet plus 5 plus 14, that would give overall 76 showing 76 feet. And then I'd have to subtract 10 from that, so that would be 66 feet to go
Yes,
towards a building.
yep,
Okay, so 6.5, essentially 6.5 feet by 66 feet.
yes. And intentionally, we were not putting the foundation within that 10-foot variance that we're requesting, so it would just be a deck essentially. So we'd have a couple of posts. So we were trying not to, we're not trying to push it crazy, but we just, I don't know, we're trying to connect to that house as much as we can. So.
Okay. John, Greg, any further questions before I go on to other views?
I think I'm good. Tom probably has something.
I guess my only comment in looking at it was that the setback, it was stated that the setback has changed over the period of time that they owned it. And from my information, the setback numbers have been in place since 1994. And if Alex or Sandy can correct me, they can go for it.
It's the require. I think they're referring. Well, I'll let them answer, but
It's the change to having a requirement of the existing footprint or existing structure. So that changed it so that we couldn't just request the sort of more standard setback reduction.
My comment is that the 30-foot setback from the road and the, whatever it is, 20 feet on each side apparently has been in place since 1994. Sandy or Alex, can you say anything?
Yeah, I can maybe clear that up a little bit. I think what what you're looking at is there was a surveyor in 2016 originally shows a 10-foot setback from the road because he is assuming he based that on a section in the shoreline zoning provisions that allows a 10-foot front setback or a setback from the right-of-way of 10 feet if that property owner owns the right-of-way. So there is a possibility that they own the right-of-way, and if that's the case, then they would have a 10-foot setback from the right-of-way. Actually, I think the travel portion of the right-of-way, wherever that is. So that's on that original survey. If you look, it does show that. One of the things that's kind of unusual, though, is he shows the lot line not including the right-of-way. But then there's a note that says it's assumed that the property owner may own the right-of-way or something like that. But nothing has changed. I believe only thing that may have changed would be an interpretation. That could be the thing that's changed. But the ordinance itself has stayed the same there. They are correct. The 2020 amendment, I believe it was 2020, to add the requirement that there needs to be an existing single family is what's preventing them from getting a setback reduction.
All right. So Matthew and Sarah, unless there's anything additional you want to add right at this point, I'll go ahead and open this up for other people's comments. Certainly, you can add to the conversation as we go through things here with additional public comments. Okay. Okay. So at this point, do I have anyone here in the Zoom audience or by phone which would like to speak on behalf of this application as to being for it? And I'll ask Sandy or anybody who may be able to answer, do we have any indication that there's anyone on the phones? I don't get that impression from my limited view.
No, not that I can see either.
Okay. So with that said then, do we have anyone here tonight on Zoom that would like to speak in opposition to this application?
Hello,
Hello, I see Andy speaking.
I'm the old guy. Yeah, I approve of what they want to do next to our place. If that is indicated.
So Andy, for the record, can you just, you've indicated that you're for this. Can you just give us your full name and your property and your address, please?
Andrew J. Weiland, MD, 65 Jordan Lane.
35.
Excuse me, 35 Jordan Lane. So what happens you get to be 80? Raymond Maine.
Very good, thank you. So we will then ask, is there anyone here tonight on Zoom that is looking to speak on behalf of this application, but in a neutral status?
So David, this is Greg Perry. I'm 31 Jordan Lane. Are you gonna read the letter that my father Tom Perry put out ahead of time, or do we kind of be redundant with that?
Well, yeah, give me 1 second here. Thought I was in better organization than I currently am. My intent was to have, if Tom was here, give him the opportunity to speak, and if he wanted me to read the email, I would do that. If Tom were not here tonight, I was going to read his email to us into the record.
So my dad can certainly speak for himself here, but I wanted to make sure that the mechanics usually, I at least from my experience, the letter is read and then public comment, but maybe he can you want him just to read the email that he wrote?
I am certainly,
the way it's positioned where you say opposition, we're not really opposing. The issue
Yep.
is making sure we don't hinder our own ability within our own rights, not asking for anything above and beyond. And that's obviously his point.
sure, yeah. So if you're really, the three options are for, in opposition, or in neutral. Would you say neutral is the best classification of this?
Yeah, I think that's fair, as long as it meets the criteria. I think my father should probably speak on this and has a better understanding though.
Okay, and you know what, I will, we do have a letter which was submitted by Mr. Tom Perry on Wednesday, January 19th. I'll go ahead and read this email. And if Tom, I do see that you're here, so if you wanted to add anything to that, you certainly can after that. So the email which was sent says, good afternoon, Ms. Fredericks and members of the Raymond Zoning Board of Appeals. My name is Tom Perry, and along with my brother Stephen, we own the land and structure at 31 Jordan Lane that is adjacent to and northwest of the Holland property on Jordan Lane. The Holland property setback variance request, as you know, is on the January 25th Zoning Board of Appeals agenda. I have attended the last two site walks with my son Greg, and I attended the last public hearing regarding the Holland property on October 26, 2021. We very much want to be good neighbors to all our neighbors, and that certainly includes the Hollands. Our only concern regarding the new Holland plans is that they do not affect any of the future plans we may have for our property. We stated this concern at the public hearing and discussed the same with the Hollands at both site walks. Just to clarify, it appears from the Holland site plan that their proposed sewer chamber is 10 feet plus or minus from our property line. And our concern is that this could possibly adversely affect our future plans to request and hopefully obtain approval for placing a foundation under our existing structure, drilling a well, and constructing a new septic system, all while under current setbacks and laws. It is my understanding that the current recommendation is that there be a minimum 100 feet between a well and a septic, and this clearly restricts the placement of both on our property, even without the concern of having our well be 100 feet from the Holland sewer chamber. Does this concern pose a potential problem for us as adjacent owners? Thank you very much, Tom Perry. Tom, if you'd like to add anything to that, certainly we can listen. Otherwise, I'm going to ask Alex to just provide some insight to us in regards to that. I can't tell. I think you might. Are you talking, Tom? If so, or you're on mute.
Sorry about that.
Oh, no problem. You're
I've
good
been
now.
talking quite a bit during this. I just realized I was on mute.
Oh,
No, thank you very much for reading that. I
yeah, of course.
don't really have, I don't think I really have anything to add at this point. That is our concern. Without being repetitive, that as we move forward, we want to be able to do what we hope to do in the future with the town of Raymond and with our property. Other than that, that's really our concern at this point. So.
Okay. I am going to ask Alex if he can provide some additional insight. I will say that looking at this, I believe that the proposed sewer chamber that's being referenced is on the side for which there is no setback reduction being requested. So, but Alex, if you have insight for us, that'd be great.
I actually have a question for the Hollands. The septic location is shown on the plan, but I'm just curious, is there a septic design that was done or a test pit or anything done for this to put it in that spot, or is that just kind of an idea?
We have not done any soil testing. We were, waiting to see what the result of this was before we were going to go down that route. But we have reached out to an engineer who did walk us through what was possible and the setbacks that would be required. The type of chamber, the system is a, let's see. It's one of those sort of high-tech chamber systems that does the aeration, and so it's a smaller field than typically. It's taking that percentage down from the 100% typical, I believe, down to 75 or 50% for the disposal bed.
So without really having a design or test pits or anything, looking at the proposed request for a variance, there really isn't any other spot that would be suitable other than the south side if the variance wasn't granted, allowing the structure to be built on that side. Because obviously, with a septic system, you have setbacks that you have to meet from a property line. They're not the same as a structure setback. It's typically 10 feet from a property line. But you also have setbacks from a structure, like they show on the plan, 20 feet down from there if you get a variance. There really isn't any other spot because you do have a setback from the water, the 100-foot setback as well. So they are extremely limited. David, I'm not sure if there's any specific questions that you guys might have for that. But without having more information, it's tough to tell. It looks like they're basically limited to the north or south side of the lot.
Right. Am I just as looking at this and in regards to the fact that there's not a setback reduction being requested from that north side, I don't know that I appreciate certainly the Perry's concern as adjacent landowners, but I'm not sure in regards to the specific setback variance request, if there's anything additional that we need to consider with that.
Yeah, the way that we often, because this is pretty common, we run into this a lot, we have to review any application for a septic system based on what exists today. So wells, structures, lot lines that currently exist today. We can't really base the approval for a septic system based on, possible future development. That's where it gets a little bit challenging. There has been situations where there are certain recorded restrictions, and it can kind of get complicated. But when we review a septic system permit application, we are basing it on, well location, structure location, lot line location for today, and the soils for today.
Alex, can I jump in real quick? Or
Well, did you have a specific question there for Alex? Greg?
I just wanted to follow up on what Alex mentioned, and it's, I'm in commercial real estate, so I see this a decent amount, but it creates kind of a domino effect, right? So what happens is you have one property that says, okay, I want a septic. And then all of a sudden the next property down has to go to their far edge. And then the next property down eventually ends up in a position where they cannot put a septic system in. And so the granting of this variance, it suddenly becomes, it's no longer in our control in any way. We have no say on anything. But what you're saying is, even though our camp, that's been there for, my father could jump in, but since the 50s or early 60s, it is an existing structure, but does not have the septic in place. We would all of a sudden not be able to put a legal system in because they're putting something in that's newly built. And so that's our only concern. We can't be the last domino to fall where we're in a situation where we can no longer, on a property we've owned and maintained for a very long time, do what's best for the environment, switch over to a well, go into the septic system, if we're not allowed to based on where they place things. Am I incorrect on that, Alex, as far as the domino effect?
It really depends on the widths of the lots. You could, if you don't have a septic system and a well on your lot currently, it really depends on where the septic system is for the property owner on the other side, too. Because if you have a situation where you don't have a septic system and these guys get the variance and they end up putting one in on this north corner, you could also put one in on your southeast corner and put your well on the other side, depending on where that septic system is over there. I don't know where that is, or if they have a well and a septic already. But
the lot on the other side is actually an empty lot. There is nothing on the other side.
So that may factor in as well. I mean, if there's no septic system on that lot currently, then your other side of the lot may be open for a well. You obviously have a 100-foot setback from a well. You can do for replacement systems. You can do a variance essentially for a septic system so that it can be placed closer to the well with casing depths. But typically for a first-time system, we're looking at 100 feet from a well.
Okay, I guess my point is just to make that point. I think it's important for people to understand that aspect. And again, we'd run into the same problem on our north side with the merchants saying, this isn't something that we're going to be all that in favor of for the exact same reason. So it does create a domino effect. And as I said, we certainly want to do what we can do within our legal rights. We just don't want to be infringed upon as far as our ability to do that.
Mr. Chairman, my name is Tom Greer. Can I ask a question here or add some comment?
Tom, if you can just also state your address, please, and if these comments are being done in favor or opposition or neutral with regards to the application.
Yeah, I'm in favor of the application. My name is Tom Greer. I live at Anthorn Road in Wyndham, Maine. I am Sarah's uncle. I attended the site walk last time. With regards to the septic system on that side of the lot, it's easier to get their septic system adjacent this one. Whereas if it gets flipped and they end up putting a well on that side, it's harder for them to get a septic system variance for the well that would go on their side of the property versus the septic system. So I think the site design as put together is really as favorable to the Perrys as it can be.
Yeah, we still require we will require a variance most likely.
Your well would require a variance, but it's easier to get a well variance than it is to get a septic system variance. So putting your septic system adjacent theirs 100 feet back from the lake, you would put your well on the opposite side of your lot. It would be within 100 feet, but that's that's an easier thing to do versus getting a septic system variance to be 100 feet from the well if they have to drill their well on your side of the property.
So I'm going to interrupt here just for a minute. I know it's kind of difficult when we've got Zoom here, but all conversations, as we stated in the beginning, need to be directed to the chair. So I appreciate there's some good feedback here going on, but any conversations really need to come to me first and then get redirected from there. I'll also bring up too that I do think these are all valid concerns from being property owners. I think as a zoning board of appeals, we're looking at this specifically as to can we grant a front setback and a south side setback for the Hollands, and if neither one is granted, they still have the ability to build on the property, and these will still be issues that are possible regardless of whether the variance is granted or not. So they could still, like I said, that north side doesn't have a variance request. So there's no setback variance being requested for that north side. So I think that the concern will still be there regardless of whether or not this variance is accepted or not. So Greg or Tom, do you have any further questions before I close out public comment?
This is Tom. I guess one of the questions, and Alex can chime in, is the septic tank has a requirement and the leach field or chamber system has a requirement for setbacks. And I noted in one of the designs layout, it says the 15-foot setback for the septic chamber from the porch posts, but there's still a carport in there. So I assume the carport also has the port posts that should be designed into it. So
it would actually cantilever out over, there's no support for it. The support's from the building itself. And I've talked with an engineer about it. So.
Okay, so Alex, can you clarify what is the tank setback requirements and the chamber requirement?
So a tank for a first-time system, the setback requirement's 8 feet. And for a field, it depends on the type of foundation for the structure. If it's posts, slab, or a below-grade foundation. So a below-grade foundation is the most strict setback. That's the 20-foot, and then for posts, you're looking at the 15-foot. But there are also, there are variances that come into play, and the question often comes up, where's a setback measured from? If it is measured from the actual foundation, if it's a deck, do you measure from the post or the edge of the deck? Those are all valid questions, but I don't know that it necessarily is important for this meeting, because that's something that's handled through the code office with a permit from the code officer. So I don't think you guys need to get too buried in the weeds on that stuff.
You all set, Greg?
No,
I was just going to ask. I don't know. I think he might be talking to me, but I'll give him a chance to specify a last name.
Oh, sorry. I meant to say Greg Dean. I apologize.
Yeah. I think Alex. We've spent a lot of time on the north side of the building. I understand we want to make sure everything's landowners have their interests represented here. But Alex, so nothing on that north side influences the setback that we're discussing in terms of the road or the south side. There's a whole bunch of permitting and stuff that will have to be done no matter what in terms of
Yeah.
And it's okay. So we're not
It definitely doesn't affect the road setback at all. It could affect the south setback. If you didn't have as much of a setback from your septic system, you may be able to push the structure up, but it doesn't look like there's any room to go there. It's pretty much maxed out on the north end with what's shown on this. Granted, it's not, it's not done by a site evaluator, so we don't even know. I mean, that could be all ledge there, for example, and that could kind of mess up the plans for putting it there. But based on what we see here, there's no more room to play with on the north side, from what I'm seeing.
Okay. All right, and I think if we wanted to, we could make it conditional of approval of whatever needs to be done on that north side too, because I assume that all needs to be permitted and inspected, and soil needs to be done, and before anything gets actually committed to. Okay, I'm good.
Before I close out public comment, Sarah, Matthew, do you have anything else you'd like to add, given the conversations we've had so far?
No, thank you for hearing us again today.
Thank you.
Okay, very good. So I'm going to go ahead and close out public comments. At this point, we as a board will need to review the town of Raymond's ordinances and see how they apply in regards to this appeal. I will say that Sandy Fredericks had reached out to the Maine DEP, Department of Environmental Protection, about this request, and their response from Jeffrey Kalinich, the Assistant Shoreline Zoning Coordinator, said, "Hi Sandy, this variance application is for road and sideland setbacks. The mandatory Shoreline Zoning Act does not establish minimum road and sideline setbacks for municipalities to apply. Road and sideline setbacks are determined locally. Thank you for submitting the variance application to the department for a project located in the shoreline zone." So essentially, Maine DEP is leaving it for us to decide. Looking at our ordinances, we have, we're going to be looking, property is in LRR1, which would be shoreland zoning. So we have the town of Raymond shoreland zoning provisions. Looking at section 16 for administration, subsection G for appeals, further subsection 1, powers and duties of the Board of Appeals. The Board of Appeals shall have the following powers, and then section to this is variance appeals. So the Board of Appeals has the authority to authorize variances upon appeal within the limitations set forth in these ordinance provisions. So we as a board do have the authority to do that. Further section 2, variance appeals, indicates variances may be granted only under the following conditions. A, variances may be granted only from dimensional requirements, including but not limited to lot width, structure height, percent of lot coverage, and setback requirements. Our appeal tonight is for setback reductions, really setback variance. So we do this appeal, and Greg Dean and Tom Hennessy, if you see that or believe that I am misinterpreting these, certainly feel free to say something, but I believe we have authority to speak to this. Section 2B, variances shall not be granted for the establishment of any uses otherwise prohibited by these ordinance provisions. Looking at our shoreline zoning ordinances, if I go back to the table of allowed uses, one of the tables of allowed uses is for a single family residential, which is what we are looking at tonight. So I believe anyways that we have authority over that type of a setback for a setback variance with regards to that use. Section 2C, the board shall not grant a variance unless it finds that number 1, the proposed structure or use would meet the provisions of section 15 after for the specific provision which has created the nonconformity and for the relief for which relief is sought. So Alex, I need your feedback on this because section 15 of the ordinance covers a lot in regards to shoreland developments. Let me try and get my ducks in a row here. So if I go to section 15, if I immediately go to 15 land use standards, number A is minimum lot standards. And a minimum lot standard for LR1 is 2 acres. Does that sort of automatically block us from going forward? Or how do I need to look at this part of the ordinance, which says we need to ensure things match up under section 15?
Okay, so what you're looking at, so the proposed structure or use would meet the provisions of section 15 after for which can't talk tonight. Specific provision for which has created the nonconformity and from which the right.
Yeah, and I'm wondering to what level of section 15 we need to look into with regards.
So what they're proposing is to meet all of section 15 with exception to the front setback and the side setback. So you can realistically base your decision on the fact that they're going to get a building permit and they're going to comply with all the other requirements of section 15, but the front setback and the side setback. Because they have to get a building permit.
So if I'm looking at this, then where section 15A says minimum lot standards and setbacks, lots shall meet or exceed the following minimum lot size requirements. Limited residential, recreational 1, 2 acres. I mean, this lot is not a 2 acre lot. Does this automatically block them from?
No, it's a legal non-conforming lot of record, so it doesn't need to be a 2 acre lot.
Okay. So I guess Greg and Tom, I think we at least need to take a look at section 15 here of the shoreline zoning provisions for land use standards and, see, is there anything here specifically that would stop them from proceeding with the variance? I mean, there's a lot of stuff here.
Are you asking me?
Yeah. So either Greg.
He's asking me.
Yeah, if I'm saying Greg or Tom, I'm specifically asking for my zoning board members.
Well, I think Alex, I don't want to draw too much from maybe something you subtly dropped in there, but it sounds like you're from section 15. You said that everything is fine as long as the setback variances are granted, right? Is that what you intended to say, or?
No, so they can't build what they want to build because they currently can't meet the setbacks.
Right.
So they're applying for this variance so that they can apply for a permit to build this structure, and they can't get a building permit if they don't meet the requirements of section 15. But they also have a non-conforming lot of record here, so they don't need to have a 2 acre lot, for example, in order to apply for a variance.
So we, as the zoning board of appeals, what responsibility do we have towards section 15? Or is that responsibility more under code enforcement as part of a building permit application? I mean, I want to make sure we're doing this correctly. And if we need to go through aspects of section 15, I want to do that. or if these are already going to be covered. Or if I just don't want to get to the point where we're granting a variance and then come to find out we really should have taken into account some aspect of section 15 before providing that or for granting that variance. I know Alex is looking, but I guess one of our other options can be, but you know, we could grant it with conditions that says, you know, if we choose to grant the variance, that it can be granted, you know, with under the condition that the building permit or what's being requested to be built satisfies, you know, section 15.
Yeah. How long does the variance, if approved, it has a time frame for the building to be put up anyway, right? Isn't that like a year or something like that, or is that my mistake?
Yes. Yep,
Yeah.
there is a time
So,
frame. I don't know
actually,
off the top of my head.
Yeah, I actually think we're covered because we can approve the variance and they have to do the permitting and the soil and all the stuff. And if they can't, that's not really the variance will just expire, or they have to redesign or, you know, change their plans. But that's my thought, is that we're kind of covered by the process that follows this. But
yeah, I mean, I'm comfortable with that as well, Greg, just as long as, and I don't hear Alex saying there was some aspect of section 15 we needed to review in conjunction with this. But if section 15 really falls under code enforcement and a building permit process or any other process that falls outside of ZBA, I'm good with that. I just don't want us to miss something that we should have addressed. That's all. So let's go ahead, and looking like Alex might be reviewing some of this, so we can potentially skip past and come back. Unless Alex, you got something?
Well, I mean, section 15 is essentially the shoreline zoning, the performance.
Right.
Yeah. So, and that's why I say, you know, if you guys approve this, for example, they still need to get a building permit, which is going to require them to meet all of this shoreline zoning criteria. That's tree removal. Tree removal for this project follows certain standards. Lot coverage. Lot coverage meets certain. In order to build this structure, they're proposing to meet lot coverage, but they also don't show, you know, on that. They also don't show, you know, the parking area. So we don't know, for example, what exactly that's going to look like. They're not requesting a variance for lot coverage. They're only requesting a variance for the setback reduction. So, you know, there's certain things in here. They're requesting those two, you know, a variance from those two things. And realistically, I think you're fine there, in my opinion. But you know, that's just my opinion.
Yep. I believe we're fine too. Sounded like Greg, Dean, you're in agreement. Looks like Tom has stepped away. Tom Hennessy, but we can, at this point, we'll assume that part is okay. And I'm not sure where Tom went. I'm gonna have to, Tom Hennessy, there we go. Okay, you're on mute, Tom Hennessy, so.
Sorry, I just got a glass of water.
Oh, okay, good. So we kind of, at least Greg, Dean and I are under the impression that this aspect of the ordinances where it says the proposed structure or use would meet the provisions of section 15 after for the specific provision which has created the nonconformity and for which relief is sought. We believe that and that it will be covered as part of the building permit process, and that there's nothing further here that we need to do in regards to a ZBA board. So variance appeals, again, section 2C, item 2, it says the strict application of the terms of these ordinance provisions would result in undue hardship. The term undue hardship shall mean there are 4 criteria for which we will go through. As we go through these, I'll read what our applicants have provided for feedback, and then we as a board will need to review these as well. I will note for both the board and the applicants, there is a document called Manual for Local Land Use Appeals Boards, and our town attorney has indicated through a workshop, not specific to this appeal, but in general, that this is a document that we can refer to in addition to our ordinances. And in that particular document on page 49, which talks specifically about hardship, it says the Maine Supreme Court has stated in numerous cases that a Board of Appeals must grant zoning variances sparingly. They are the exceptions rather than the rule. The test for undue hardship, which is outlined, is very strict and very difficult to meet, no matter how harmless the variance request may seem. And regardless of whether there is no opposition from neighbors, the board must remember that its decision is governed by the legal requirements for undue hardship and only those requirements. So I just mention that just so that we as a board and the applicants really are all on the same page in what we have to look through here. So the first term of undue hardship is that the land in question cannot yield a reasonable return unless a variance is granted. In the application, it was indicated with the following by Tom and Sarah. Says, yes, due to recent zoning changes, we are no longer able to yield a reasonable return, as we can no longer build a full-time residence without a variance. At the time of the original purchase in 2000, the lot setbacks allowed for a buildable lot, and the purchase price reflected that assumption. We've also paid taxes for the past 20 years based on the value of buildable lakefront lot. It was always our intention to build a full-time residence on the lot. Now that we are downsizing and consolidating at the end of our careers with our 3 daughters in college. So Greg, Dean, and Tom Hennessy, we as a board need to look at that first item of undue hardship and discuss whether that aspect of hardship has been met. So I'll open it up to either you, Greg, Dean, or you, Tom Hennessy, for feedback.
Well, I'll take a stab at this. I think that this is we have the strictest version, right, of what the state allows for a variance here, and I think that we've discussed this with the town attorney, in particular with the reasonable return, and the bar is extraordinarily high. At least that's my understanding. So much so that like fishing and launching a boat and like camping is considered a reasonable return. So I think it's hard to, given the rules we have, unless I'm mistaken, and Alex or David or Tom, jump in if you think I'm going off astray here, but based off of the guidance we've been given, it seems that the reasonable return is kind of an unreasonable bar. I don't know how we could actually move forward, given that fishing, launching a boat, camping seem like they can all be, accomplished.
This is Tom. I'll pick it up from there. I agree with Greg based on all our training to date that the reasonable return just means that you can't use it for any purpose at all. And even in the letter from Sarah, it states that they enjoy winter activities and summer activities. I'm sure Alex can confirm that they're welcome to put in a dock and other limited things on that lot to expand their uses even, but certainly seems to be, based on what we've been told, we are reluctant, I guess, based on the training, to make any setback reductions under this hardship clause.
Yeah, sorry, just to take that, I don't, for me, at least my understanding is not reluctancy at all. I think that we have a very narrow, I think a lot of people come in and talk to us thinking that there's a lot of opinion and nuance to, and that's true for some of the stuff, but like a lot of these things we have to interpret, or we have a very narrow window. And I don't think that like we've specifically clarified this exact issue, and it's there's, I forget the actual terms, but there's a, we have, the town of Raymond has chosen to adopt the strictest possible kind of burden on landowners when it comes to these types of variances, and we really don't have much to go with other than the land can't be used at all. It's not that it can't be used for what you wanted it to do or what you paid taxes to do, or those are all kind of separate issues. And I really hate to even have to talk about this because it's such a difficult burden to meet. I don't actually see how anybody could meet it. So given what the tools we have, that first one seems tough to get over.
Yeah, Greg, the one I recall from our training is the quote, "The practical loss of all beneficial use of the land." And we are certainly not taking away every possible use of the land.
Yeah, and we've specifically probed one of the town attorneys about like, well, hypotheticals. What if you can't build a house, or what if the only thing you can do is fish or tent or stargaze, and those are all reasonable uses of your land according to the statutes that we have. And I mean, it sounds exactly what it is. But.
So yeah, I am in agreement with the two of you. I reviewed that again, that manual for local land use appeals boards, and in section 4-1-11, it talks about reasonable return. This is a concept of reasonable rate of return has been defined in very specific terms by the court. To prove that the landowners will receive no reasonable return without the variance, they must show that they will be deprived of all beneficial use of the land. What the standard means is that they must show that the land is not suitable for any use permitted by the zoning ordinance. And I reviewed the shoreland ordinances, and there's section 14 as a table of land uses. And number one on that land use is non-intrusive recreational uses, not requiring structures such as hunting, fishing, and hiking. So if we take, what this manual has indicated, we're saying that they must show the land is not suitable for any use permitted by the zoning ordinance. But one of the land uses is non-intensive recreational uses, not requiring structures such as hunting, fishing, and hiking. I would argue that is a use that's permitted and suitable. So.
Alex, sorry, David.
No, you go ahead.
Yeah. Can you clarify? I mean, I mentioned a couple of times, and I don't know if you know off the top of your head, but there is, this is somewhat conjecture, but there is this pragmatic type of variance that the state does allow that Raymond doesn't have in their ordinances. Is that correct? I just want to get on the record about what we're talking about, what exactly we're, because I know it's probably disheartening to hear that we're, because you can go fishing, you can't build a house. It's a tough spot to be in. So I'm trying to put as much out there as I can about what we've discussed. And I believe there's this pragmatic variance that's a step down that the layperson would think what we could use, but we just can't. So.
Yeah, what you're talking about is what's in the land use ordinance, B1C, I believe it is, which allows for a variance where you can go, you can't exceed 20% of the setback, but it's a variance that has all of the same hardship criteria except for, I believe, just removing the reasonable. We don't have that in the shoreland zoning provisions. One of the things that I've been working on with the attorney, and we'll get into later under Code Office Communications, is possibly amending the ordinance in June to include that in the shoreland zoning provisions. And that may be a nice trade-off if we do get rid of the setback reductions. To put that in the shoreline zoning provisions to give